Hello, everybody. My name is John P.L.L.C, and I'm going to be speaking to you for the next 2 hours plus on advising the estate planning attorney. Specifically, I'm going to be speaking about ethical issues for the probate practitioner or the estate planning attorney. Most lawyers who have that type of practice are not only administering estates, but they're drafting estate plans, they're preparing wills, they are writing up trusts and things like that. We're going to be discussing a number of legal issues, both technical and non-technical issues today. And you'll be entitled to 2.5 CLE credits, both general and ethics as well, for today's webinar. This webinar is brought to you by my law firm, P.L.L.C. Hauser, which is located in downtown West Palm Beach, Florida. Our practice is limited to disputes, trials, and appeals involving wills, trusts, and estates. And our seminar today is advising the estate planning attorney. The course number is 1608-416, N as in Nancy. So the course number for the Florida bar is 1608-416, N as in Nancy. Okay, so let's begin. We're going to begin with some information on our discussion outline. We've got a lot of topics and a lot of cases that we're going to cover today. Then we'll go right into our introduction. And I'll tell you why we're doing this later. And I'll tell you what we hope to share with you, or what I hope to bring with you, bring to you on this webinar. And why we're doing it. But let me just say at the outset that our firm, P.L.L.C. Hauser, will be offering other webinars free of charge for Florida bar members. We have a number of webinars that are intended for the layperson. They tend to be much shorter, particularly like 30 minutes or so. But we plan to have, on a monthly basis, free Florida bar approved continuing legal education courses in the form of a webinar. And if you don't attend live, you'll be able to get a file, which is not only an audio file, but a visual file as well. You'll be able to see the PowerPoint presentation, you'll see the case citations and whatnot. We will be having one on ethics later this month. We'll also be having one on charging liens and getting attorneys paid later in the first quarter of 2017. And for information about other webinars, you can email Amanda at phflorida.com. That's Amanda at P like P.L.L.C., H as in Hauser, Florida.com. Her extension is 101, and the firm's number is 514-0900. So let's discuss what we're going to be talking about today. There's generally 6 topics. We're going to go into an introduction, followed by a very close look at what is legal malpractice. Our third discussion topic will be a focus on very specific Florida legal malpractice cases. And 20, really more than 20 things you need to know, or 20 issues that our law firm has seen throughout our practice. We've represented attorneys when they've been alleged to have maybe committed malpractice. We've also assisted attorneys with fee hearings and contentious situations where a client is disgruntled and the threat of a malpractice action may be coming down the pike, and we've been hired to try to thwart that, or at least head it off, or at least to try to advise and attempt to resolve the dispute. So those are, we put in there 20 things you need to know. There's really a lot more, and you'll see why. We're going to speak briefly about non-Florida legal malpractice cases, so you'll get a flavor for what's going on outside of the Sunshine State and see what's happening across the country. And those are all very, very recent cases from 2016 that you'll be able to look up and spend a little bit more time on later. Finally, we're going to talk about some ethics before we conclude. So with that said, let's go into the introduction and start talking about why we're here today. Let's talk about the background, what legal malpractice is, and how we get there. So everybody knows that we have rules regulating our conduct, right, as Florida attorneys, even though the public may make fun of lawyers, right, and describe us as sharks or thieves and scoundrels. The truth is our conduct and our practice are both highly, highly regulated, right, and it's very serious. And we have these strict rules of compliance. And so one of the one of the keystone or bedrock principles or rules that regulate our conduct is we need to be competent, right? Rule 4-1.1, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So you don't need to be, and I see that somebody has videoed in. Evidently somebody can, oops, forgive me. We had a technical issue that came up. Somebody had a video presentation on. So our rule of competence doesn't require us to be Bill Gates. Our rule of competence doesn't require us to be Albert Einstein. We don't have to be brilliant, but we do need to be competent. And included in that rule is a standard or a belief or a requirement that we don't accept an assignment that we're not capable of handling, right? And we may be given a little leeway to develop the competency, but we shouldn't be handling matters that we are not competent on. Right, and so you can look at the air turbine case, right? The air turbine case is a recent 2015 case from Florida's 4th District Court of Appeal, and they talk a lot about in the air turbine case about competency and what a lawyer did in rendering advice. So an attorney may be held liable for damages incurred by a client based on the attorney's failure to act with a reasonable degree of care, skill, and dispatch, right? So that air turbine case cited a very popular case called Crosby v. James, and you'll see Crosby mentioned throughout not only the presentation on ethics and malpractice today, but throughout the other opinions that have been handed down by Florida's district courts of appeal. The air turbine case was actually a gut-wrenching case, right? It's a case that provides heartburn to lawyers because the lawyer did everything right. The lawyer provided the correct advice and even was applauded or lauded by the 4th District Court of Appeal. The 4th DCA said the lawyer's advice was spot on. The rendering of an opinion or advice regarding whether attorney's fees could be assessed or not was correct. Unfortunately, the federal appellate court disagreed. And that federal appeals court decision went back down to the federal district court, but this 4th DCA resulted from a malpractice action. So that was a frustrating case because the lawyer actually did everything right, even though the federal district court agreed. The federal appeals court said no. There's a difference here regarding attorney's fees. And on the malpractice action in the fourth basically said the federal appellate court got Florida law wrong. And they explained what the law was on attorney's fees in Florida and said that the lawyer who rendered those services did a fine job. So why are we here today? What's going on? Well, I guess there's a couple of reasons. One, none of us like malpractice lawsuits. None of us want to be potentially liable for errors, boo-boos, acts, and omissions. We want to try to avoid a jury trial on that. So there's a selfish reason for being here. Two, if we can better understand the issues to a malpractice action, maybe that can help us reflect or improve upon our own practice. And then finally, it seems that lawyers are becoming targets with an increasing frequency. And the probate practice, the estate practice, the administration of trusts and estates is no exception, right? And so you see a quote in the slide in front of you that the number of lawsuits against estate planning attorneys has actually increased over the last several years, and perhaps disproportionately to other areas of the practice. That's a citation or a quote or a finding from a probate and property article from 2008. And if you look at the appellate opinions in our district courts here in Florida, you're seeing a number of legal malpractice actions or professional negligence actions. And in fact, when you read cases like Dingle, and when you read cases like SATA, which we'll discuss later, you could certainly make the argument that plaintiffs are being given an easier time in court, that plaintiffs or potential plaintiffs are their causes of action and their allegations are being heard to a greater degree by district courts of appeal. If you look at the appellate opinions that we're going to be discussing today, you will see a number of summary judgment issues or motions to dismiss that were granted in favor of the law firm or the attorney that are overturned upon appeal. And so in a post-Dingle world or post-Sato world, what you're seeing is you're seeing the courts expand the rights of plaintiffs to bring lawsuits against lawyers, right? You could certainly make that argument that it is easier than ever before to survive a motion to dismiss or a summary judgment motion. If you're a plaintiff, it's getting easier to sue attorneys for estate planning malpractice or malpractice relating to gifts or estate administration. But behind that, right, behind all of that, if you have an estate practice or a probate practice, is this massive wealth shift, right? The Boston College Center of Wealth and Philanthropy estimates that 56 trillion, not billion with a B, but trillion with a T, is being transferred from the World War II generation down to future and other generations, right? The millennials, Gen X, Gen Y, the baby boomers. It seems everybody's fighting over that, right? And lawyers are not immune from the probate wars. So if you have a practice and you're involved in families and estates and trusts and inheritances, please be mindful. I know a lot of you people out there don't handle litigation. You draft wills, you prepare estate plans, you might draft FLPs, you might just do simple meat and potatoes wills and trusts and rev trusts and maybe a life insurance trust or something, and healthcare documents and powers of attorney, and you don't litigate, but you're going into court and you're participating in hearings which are evidentiary in nature. And so I know a lot of you probate practitioners or tax lawyers now are heading into court, and not just to open up an estate or to get your fees approved, but to advocate. And you're answering petitions for revocation of probate, and you're answering contested petitions. And you need to be careful about that, because if you're doing that, you have to be competent in that area. So what do we hope to do today? Well, for the next hour and 40 minutes or hour and 50 minutes and so, I hope to lend to you some perspective, right? I hope to present to you some of the issues that we at our law firm, P.L.L.C. Hauser, are coming across, right? We as litigators, because we don't prepare estate plans, we don't write wills and trusts, we don't do any drafting, we only handle disputes, trials, and appeals. And so I don't know that you're going to get any best practices today, but hopefully you'll get some better practices as we head down our highway to heartburn, right? Some of the issues that we're going to discuss today, as my law partner, Rob Hauser, would say, give us heartburn as lawyers, right? It gives us concern. And so we're going to share some of that perspective with you today. So let's get right into it. Let's get into the meat and potatoes, the nuts and bolts of this. And let's talk about what is legal malpractice, right? What are the elements of a cause of action for professional negligence or legal malpractice? And remember, when we talk about professional negligence, we've got to remember that the rules are different for lawyers, right? We're not civilians. We're not accountants. We're not contractors. We're not normal or regular service providers that the law and society view us differently. We're in a fiduciary position to our clients. We have oaths that we take. We have obligations that we're required to comply with because we deal with really important stuff. So what is legal malpractice? Well, there's generally 4 elements. You've probably all seen this before. You generally need to be employed, right? That means you have an attorney-client relationship with somebody, right? So in our firm, what we do is we have a legal services contract that every single client signs, right? We prepare it, we send it out to the client. We invite them to get an independent, objective review from their own attorney or from a separate attorney different than our firm. But we want a legal services contract setting forth our terms, setting forth our compensation, and also setting forth some of the rights of the clients. So generally, in our context, there's no discussion or dispute over whether we had an attorney-client relationship with somebody. There was employment. And you probably all know about the privity exception, right? That you have to be employed by a client, or you have to be in privity with a client or the plaintiff. And you see the McLeod v. Bankier case that is cited there. You need neglect of a reasonable duty, right? And you need proximate causation, right? The neglect led to damages, and that's the fourth element, right? A client's loss, damages. And so you see the Larson and Larson case being cited quite often for that proposition. So let's talk about causation, and then we're going to speak about damages a little bit before moving on to more interesting topics like defenses, what a lawyer's defense is, and specifically we're going to talk a little bit about the concept of judgmental immunity in Florida, a concept that's still evolving. Well, so if the client cannot show that it would not have suffered harm but for the attorney's negligence, the client's case fails, right? That's the KJB Village property case. So the client has a duty, right? The plaintiff has a duty. If the client can't show that it would not have suffered harm but for the attorney's negligence, the client will not prevail. So that's kind of another way of saying you almost have to win a case within a case, as some lawyers describe legal malpractice, right? The client must win a case within a case, must demonstrate that the client would have won on the underlying matter but for the attorney's negligence, and that's the Hansen case that's cited there. So when we have legal malpractice cases, the courts do differentiate between the different types of services that are provided by a lawyer. So if you're handling a trial or you're handling evidentiary hearings, that trial work may be subject to a particular standard or particular unique aspects that courts are going to look at, versus the negligent will drafting case, right? The bad estate planning case, which to me poses some great concern for the audience, right? If you're an estate or a probate lawyer, we need to be concerned about negligently preparing an estate plan or a will. And some of the in some of the materials, and later on today, we're going to be speaking about that context, that hypothetical. And to me, one of the challenges for you estate attorneys or you probate lawyers, those that prepare estate plans, is the beneficiary who might sue you. You know, mom or dad come to you and say, I want to put Johnny in the will. Johnny's not in the will. Put Johnny in the will, and you just don't get around to drafting the will. You don't get around to having the client sign it, and then the client dies. Can Johnny sue you for legal malpractice, right? And that is the courts generally call that the will drafting issue for legal malpractice. A decidedly different set of facts, a decidedly different analysis by a court than if you blew a deadline on an appeal, right? Or if you blew a deadline in the administration of an estate. You know, you missed a deadline and there's interest and penalties that were due or something like that. A much different analysis. Causation. Damages, don't forget the damages. You got to have damages, right? If you don't have damages, you haven't satisfied the last element of the cause of action, and your legal malpractice action will fail. We can have a discussion about whether nominal damages and only nominal damages are sufficient, or whether a claim for a legal malpractice would fail if there's only nominal damages. But you know, when we read district courts of appeals, their appellate opinions, we see recurring themes, right? Summary judgment motions or summary judgment orders are often the subject of appeals. And many times those appellate opinions are overturning summary judgment orders and finding that there are disputed facts, or finding that a court should not have granted summary judgment because the trier of the fact, the judge or the jury, should have heard all the evidence. Another aspect that we read about Another, to me, another theme that we see from appellate courts, although certainly not as common, is the lack of damages. I mean, how many appellate court decisions do you read where they say, you know, you had a great case and you did a very nice job, and we thought causation was right on, but you didn't prove damages, or I didn't hear about damages, or, you know, I would have liked to have heard about blah, 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 that related to damages. And so that's kind of like a trial lawyer's nightmare, right? You can't forget about that last element. And whenever you're handling these types of matters, you want to try to sit back and say, how, you know, what was the damage? Is it quantifiable? Can I put my finger on it? And certainly the plaintiff needs to do that. So don't forget your damages. So the test for determining when a cause of action for attorney malpractice has accrued is whether the existence of redressable harm, that's kind of the buzzword among the appellate courts, has been established. And they cite the Pete Marwick case for that, right? The Pete Marwick case, which talked about redressable harm and tax services which may or may not have been faulty, and the fact that the redressable harm generally happens when the damages have been established. And I guess a simple example of that would be you do some tax work and a client gets a deficiency notice, and there's all this interest and all these penalties that are due. And so the tax provider or the tax service provider files an appeal, and it goes up the chain of command, and the client fires the tax service provider and sues them for malpractice. But there's an appeal, right? It's going up the chain of command. The interest and the penalties are being questioned. And so Pete Marwick kind of holds for the proposition that, look, what if you went on appeal and there are no interest and penalties, right? Then you know, what if the tax preparer or the tax service provider was correct and the IRS was wrong? Then you really don't have any damages, right? So when does redressable harm occur? When is that established? You can read a little bit more about that in the 1990 Pete Marwick case from Florida Supreme Court. You can also see the Coble v. Aronson case. The test for determining when a cause of action for attorney malpractice has accrued is whether the existence of redressable harm has been established. And that concept is typically cited for litigation-related matters, right? So when we see legal malpractice cases, the recurring motions that we see, whether it's a motion to dismiss or motion for a summary judgment, repeatedly deal with standing. You know, the plaintiff can't sue me because I wasn't his attorney, or I wasn't her attorney, or I wasn't in privity, or the client wasn't in privity with me, or statute of limitations, right? Or you know, causation, or you know, there's no harm. You know, this is just a beef. You don't like me. You weren't happy with the services. I'm sorry. Or we have a fee dispute, but there were really no damages. So we talked about causation. We talked about damages. We're going to talk a lot about duty later. We're going to talk a lot about who is owed a duty, and you're going to see that legal realm is expanding in a big sort of way. But let's talk a little bit about defenses now. We're still on the topic of the elements of the cause of action for legal malpractice. Let's talk about defenses, because a couple of them are really, really important. And so, of course, you know, one defense is I was never your lawyer, right? I never agreed to be your lawyer. We never contracted to provide services, and I don't know what you're talking about, but I ain't your guy or I ain't your girl. And so one thing that we do in our firm when a prospect calls us, and after we run a conflict check and after we determine that we can speak with the prospect, if we don't get hired, or if we don't hear from that prospect again, we send them a no representation letter, merely confirming in writing that, you know, look, it was great chatting with you, but we're not your lawyers and you're not a client. We're not providing any services for you. So we have a clear paper trail, a clear record that we communicated around this time about this topic, and we're not your lawyers, and we're not doing anything. And if we can advise them, if we know enough about the case to advise them on the statute of limitations, we'll tell them about that in writing. Another defense is no privity, right? Yeah, I provided services for somebody, but we weren't in privity, plaintiff, and you either have to be a client to sue me, or you have to be in privity, and there was no privity, and sorry, you don't get to sue me. You're looking to the wrong pocketbook to get damages. A third defense, of course, as I think every lawyer knows, is the statute of limitations, right? Particularly short, 2 years. Section 95.11. 4A, the period of limitations shall run from the time the cause of action is discovered or should have been discovered with the exercise of due diligence, right? So you have 2 years to sue for legal malpractice, and it begins to run when the cause of action accrued or is discovered or should have been, right? And it actually puts some burden on the plaintiff, right? The plaintiff is supposed to exercise due diligence, right? Not reasonableness, but due diligence, which to me is a little bit more. Settlement. What if you actually settled the case? And what is settlement, right? What if your client calls you up and says your fees were outrageous, and you told me to do this or to do that or to accept the settlement offer, and I did, and now I'm unhappy, and your fees are outrageous, and I also think you neglected your duties to me, and you provided bad advice, and you did all these terrible things. What if you settle that fee dispute? Do you also settle the underlying claim or the potential malpractice claim? What are you settling? What are you resolving? And so one challenge for lawyers when they're faced with a disgruntled client and the client wants to negotiate fees is to say, okay, I'm happy to talk with you. I'll be pleased to attempt to resolve the fee issue. But should we get a mutual release? Should we agree that there's nothing else coming down the pike? Because most lawyers don't want to settle a case and give up some fees on a Monday and then get sued for malpractice or anything else for that matter on a Tuesday. So if you're resolving fee disputes that aren't in a court, like a petition for fees or something, or maybe even a petition for fees, one question you have to ask yourself is, are you getting mutual releases such that you intend to resolve any and all claims for malpractice or fees or anything else for that matter? Okay, let's continue with some defenses. We know that you can generally not assign, you can't assign a legal malpractice action. So if somebody sues you and they say, I got this assignment from so-and-so, generally they're not a valid plaintiff because legal malpractice actions are not assignable. And then, the whole issue of proximate cause or causation arises if you're fired, right? If you're discharged, right? Or what happens if the attorney-client relationship ends because you quit, right? You said, yeah, I don't care to represent you anymore. And then some purported harm comes to the client, right? Well, we have an obligation and an ongoing duty to look out for and protect our clients, right? We can't just say I quit, or even if we're fired and that client is looking for a new attorney or a new law firm, we can't just put our heads in the ground like an ostrich. We have an ongoing duty and obligation to continue to advocate for the client, at least protect them, inform them, and look out for them, which can be something as simple as disseminating information, sharing data, forwarding emails, and asking the court for more time, or asking the court for a delay, or informing the court that we've been discharged and that the client needs time to retain new counsel. And then finally, judgmental immunity. What the heck is judgmental immunity, and why is it all alone on a slide? Well, judgmental immunity is a very, very important case, or I should say a very, very important concept that we see repeatedly mentioned in district courts of appeals, opinions, right? Appellate opinions in Florida, the issue of judgmental immunity. And the Supreme Court case that seems to be cited the most is a 1998 case called Crosby v. Jones. Crosby v. Jones, consistently cited and interpreted by our district courts on judgmental immunity. So let me tell you a little bit about judgmental immunity, give you some quotes and some sound bites from the Crosby case, and then we'll try to figure out what the heck it means. So Florida has long held that an attorney may be held liable for damages incurred by a client based on the attorney's failure to act with a reasonable degree of care, skill, and dispatch. All right, well, we all know that, right? Attorneys need to be competent, right? And your failure to act, not just doing something incorrectly, but not doing something you should do, can expose us to liability. This does not mean, however, and this is wonderful pro-lawyer language. This does not mean, however, that an attorney acts as an insurer of the outcome of the case, right? So don't be making guarantees, don't be making promises to your clients, and certainly don't put that in writing to them. If anything, you should do the opposite. You should tell them, hey, I will fight for you hard, I'll be your advocate. I don't know what the judge is going to do. I don't know what the jury's going to do. And I can't make any guarantees to you. All of our clients want direction, they want guidance. I mean, one of the things that you can do is to attempt to give the client possible scenarios, right? Here's your worst case scenario. You lose and you get assessed with fees and costs. Here's your best case scenario. You win and the other side is assessed with your fees and costs. And there may or may not be a gray area, right? In the probate litigation context, many times there is no gray area. The will is valid or it's not valid, right? The trust amendment is valid or it's not valid. Very little gray area. The joint bank account is a convenience account and it goes to the estate. It'll be probated and distributed under the will versus the joint bank account is not a convenience account. It's a survivorship account and it goes to the named beneficiary, right? Good faith tactical decisions or decisions made on a fairly debatable point of law are generally not actionable under the rule of judgmental immunity. Good faith tactical decisions or decisions made on a fairly debatable point of law are generally not actionable. Boy, that sounds like a big, broad defense and a big, broad exception that is overly pro-lawyer, doesn't it? So now, before, and as you can imagine, there's district courts of appeal opinions that talk all about what judgmental immunity means and interpreting the Crosby case and trying to determine whether anything done is good faith, in good faith, is a proper defense, or whether something is a fairly debatable point of law. And where do we see that a lot? We see that a lot in 57-105 matters, right? Where, 57-105 was intended to try to minimize litigation or baseless positions. And the ironic part is it's probably increased it, right? Because you have certain lawyers who send you a 57-105 letter for doing anything in the world. Showing up at court, there's a 57-105 letter. And certainly there's a number of appellate opinions on 57-105. What 57-105 says is if you engage in baseless conduct, you take a position that has no basis in law or in fact, you can be sanctioned for that because we're not supposed to do that. Sure, we're supposed to be good advocates and sure, we're supposed to fight hard, but we can't do anything baseless. We can't file frivolous matters, right? And so, we need to be mindful of that. So we can't be careful. You just can't do anything in good faith and think you're going to get out of it. You're expected to understand and be competent about that area. So there's no good faith defense to a 57-105 motion or letter unless there's an area of law where you understand it and you're asking for a natural extension of it. I mean, you can be a creative advocate. I would, however, suggest that you carefully draft your response to the 57105 motion so that you demonstrate that in case you lose and it goes up on appeal. But back to judgmental immunity. Before an attorney claiming the defense of judgmental immunity may prevail, the attorney must show that 1, the legal authority supporting the asserted cause of action was fairly debatable or unsettled, and 2, that she or he acted in good faith and made a diligent inquiry into the unsettled area of the law. Okay, that's the Hayesfield case. Okay, so if you want to read more about this concept of judgmental immunity, you can read that federal case that's cited right there, Inlet Condo Association Incorporated. It's a June 19, 2015 opinion that attempts to explain, analyze, and dissect other, Florida appellate court opinions involving the doctrine of judgmental immunity. You can also take a look at that air turbine tech case, the one I mentioned much earlier on about the lawyer who actually gave good advice, rendered good advice, was right on, was spot on according to the fourth, but the federal appellate court didn't think so. And you'll learn a little bit more about judgmental immunity under there. So that was a long first topic. Let's go into the second topic, or the privity requirement. And everybody seems to know this buzzword, right? Everybody knows that. And where did the privity requirement begin? Like, I guess it starts in our statutes, right? 9511-4A. However, this is the legal malpractice statute of limitations statute. However, the limitation of actions herein for professional malpractice shall be limited to persons in privity with the professional. In privity to the professional. And of course, that is a hotly contested issue, whether somebody is in privity with the service provider, the professional, or not. And it's absolutely unique in the area of will drafting, right? And that goes back to the hypothetical or the example that I mentioned a little while ago, where a client comes in and says, Johnny's not in my will, change my will, put Johnny in, give him 50%, and you just don't live long enough, or excuse me, the client just doesn't live long enough to sign the will. And maybe you didn't draft it that quickly, or maybe you weren't that conscientious about it, or maybe you weren't as on top of it as you would have liked to have been, and it doesn't get signed, the client dies, and Johnny, who now is not a beneficiary of the estate, does not inherit under the will, is scratching his head and saying, I just met this personal injury lawyer who says they also handle malpractice actions, and they say I should sue my dad or my mom's drafting attorney for not including me in the will, right? Gives us heartburn, gives probate lawyers, estate planning lawyers heartburn. So there's this whole area of the law regarding negligent will drafting, right? Where appellate courts in Florida have looked at that type of hypothetical and have originally, I think, historically said, no. I think Florida courts have historically said you have to take under the will to be in privity with the lawyer who didn't have dad or mom sign the will as mom or dad wanted or contemplated, right? You had to be in privity with that service provider, and privity meant you had to be in the prior will. And so the court's gaze was looking at the prior will and saying, well, you weren't in the prior will, tough luck. And that's slowly eroding, right? That's slowly eroding with the Dingle case, and courts are looking more and more to the services which are to be provided and the intent of the services to be provided and the purpose of the client retaining you and you accepting the assignment. What's the purpose? Well, the purpose is to put Johnny in the will. And so you see this concept of privity slowly expanding. And I think we're going to see cases where it's expanded substantially in the negligent will drafting or the bad estate planning hypothetical or example. And so on the slide in front of you, you see a citation from the Babcock case, a 2000 fourth DCA case where the would-be quote-unquote inheritors of the now deceased uncle file suit against, and that should be suit, not suite, against uncle's lawyers for not preparing the will fast enough. They would have inherited, but for the new contemplated will was not drafted and executed, right? That gives estate planning lawyers and probate lawyers heartburn, right? That's not pleasant, right? I guess litigators are faced with a very similar circumstance on trying to determine when to depose somebody or not depose somebody, and then the witness dies before the deposition occurs, right? That's not pleasant at all. So, but in the Babcock case, the uncle retained counsel to prepare a new will, naming 9 nieces and nephews as beneficiaries, right, who were not beneficiaries under the prior will. The lawyer evidently knew that the client's health was failing. Not good facts, right? The lawyer, and so there was this sense that time was of the essence, right? And the draft will prepared, but the uncle died, so the uncle never signed it, right? And so the Babcock case, or the court, actually dismissed the complaint. The dismissal of the complaint against the lawyers was upheld. The order from the lower court was affirmed, and they cited the Espinoza case. So in this Babcock case, which is now 16 years old, over 16 years old, it's a 2000 case from Florida's 4th DCA. The complaint alleged that the defendant had been retained to prepare a new will for the decedent. Defendant was advised that the decedent wanted to change his prior will and make his 9 nieces and nephews who were not bennies under the prior will, bennies under the new will. And then the court examines the Espinoza case, right, a 1993 Florida Supreme Court case. And in that case, the issue was whether a child of the decedent who had not been named in a prior will could bring suit against the lawyer who had neglected to draft a new will, including the child. The Florida Supreme Court held that standing in legal malpractice actions is limited to those who can show that the testator's intent as expressed in the will is frustrated by the negligence of the testator's attorney. Because the child in Espinoza had not been named in the decedent's prior will, the child did not qualify as an intended third-party beneficiary, which is the theory on which this type of action is grounded. The child could not accordingly bring a legal malpractice case. Well, if you're a plaintiff, that sounds kind of tough, right? I wasn't in the prior will. I get that. My uncle or my dad or my mom went to you, lawyer, because I wasn't in the prior will. They wanted to put me in a new will, and they wanted to hire you and pay you to draft that will. And you knew they were sick, and you agreed to draft it, except it was never signed. And the court said, I'm sorry, you weren't under the prior will, and you're not in privity. And that's slowly eroding, right? That is slowly eroding. The gaze now from Florida's District Courts of Appeal is to look at the services that you were hired for. And we're going to talk about legal services contracts a little later and whether you can draft around that, and I don't think you can. So in Espinoza, the court 23 years ago, right back in 1993, talks about an attorney's liability for negligence and how it's limited to privity, right? And it goes on to try to attempt to define privity. It's a word of art, and it's used to describe the relationships of persons who are parties to a contract. So to bring a legal malpractice action, the plaintiff must either be in privity with the attorney, wherein one party has a direct obligation to another, like a contract. You hire me to draft a will, I agree to draft a will, you agree to pay me, I will draft a will. Okay. Or alternatively, the plaintiff must be an intended third-party beneficiary. So we started the seminar by reading from one of the rules regulating the Florida bar regarding competence, and from a case that spoke to that duty of competence. And they talked about, not only are you supposed to be reasonably competent in that area to handle it, but you're also supposed to be able to be competent as to dispatch. You're supposed to do it timely. You're not supposed to, drag your feet too much, right? And so to me, on the drafting stage of this case, I mean, that's the interesting part, right? Hey, here's a draft. I prepared it. And the question might be, well, why didn't uncle or dad or mom sign it, right? Whose fault was that? And so later on, you'll hear us talking about a good and conscientious attorney always, puts things in writing and follows up with clients so that there's a clear understanding and no one's second guessing later on. All right, so that was the Babcock case. In the area of will drafting, right, our courts do recognize a limited exception to the strict privity requirement that's been allowed where it can be demonstrated that the apparent intent of the client in engaging the services of the lawyer was to benefit a third party. That's Espinoza, even though Espinoza's gaze was at the prior document, right? And that concept, again, is slowly eroding. But so let me ask you, right? We have an evidentiary issue, right? We have to some degree, a procedural issue. Do Florida courts limit their gaze to the will or the estate planning document and prohibit extrinsic evidence to determine or to demonstrate what the decedent wanted, right? We talked about Espinoza, and we talked about an intended third-party beneficiary, right? To bring a cause of action for malpractice, you have to be a client, you have to have an existing attorney-client relationship with the lawyer, or you have to be in privity. Whether somebody is an intended third-party beneficiary, and that's the exception to the privity rule, is a question of fact. And one question becomes, well, how do we determine that? Espinoza and Babcock probably say, just look at the prior will, and if you're not in the prior will, you're out of luck, plaintiff. Sorry. Other cases like Dingle, that we're going to discuss later, is slowly moving away from that. And so in the Espinoza case, there was a great deal of discussion about extrinsic evidence being admitted to explain the intent of the client, right? And the risk of misinterpreting the dead person's intent and how it increases dramatically, right? And then Espinoza gets back to the intent as expressed in the will. Well, who cares about the prior will? The client came to you to draft a new will, to make a new change, to put Johnny in the will, or to put the nieces and nephews in the will who weren't in the prior will. So why are we focused on the prior will? Shouldn't we be focused on the services that you were supposed to perform right here and right now for the client who's now deceased? And isn't that fairly easy to prove at trial? Call the drafting attorney, raise your right hand, swear to tell the truth. Why did Mr. Smith hire you? I was supposed to put Johnny and the nieces and nephews in the will. Okay, thank you. So, Espinoza, I think we're getting away from that. And my guess is, I guess on all these cases, right, when there's a dollar, when there's an estate or there's an inheritance with enough zeros on it, and when the plaintiff loses on a summary judgment or a motion to dismiss argument at the trial court, then we'll get new case law, right? So Espinoza suggests, and remember, Espinoza is will drafting, gazes upon the prior will, 23-year-old case, no extrinsic evidence, just look to the will. The privity issue for will drafting is clearly different than contract drafting, right? Because if you're talking about whether somebody is an intended third-party beneficiary of a contract, you may or may not be able to bring in extrinsic evidence about what the parties to the contract said, right? Generally, courts, when they interpret documents, they read them. And they say, this is unambiguous. I don't need extrinsic evidence. In fact, I'm prohibited from taking it. I will tell you what the contract says. I'll tell you what the document says. Or a court could say, hey, this is unambiguous. I don't understand this term, or it's not clear. I need extrinsic evidence to find out what the people were thinking. And anytime we have extrinsic evidence, right, there's always a risk that the person's intent could be misinterpreted, right? That's Espinoza. Of course there is, all the time, but that's what judges do every day. They weigh the credibility of the testimony as to whether it's self-serving or not, and they determine whether it's relevant or not. They read the document, they put all the pieces together, and they give you a completed puzzle. The Hodge case was a summary judgment case. And that was a failure to create an FLP case, right? You estate planning lawyers and probate lawyers in the 80s and 90s, you were preparing a lot of family limited partnerships, QPERTs, and charitable remainder trusts. Those, I think, are pretty much gone for the vast majority because the lifetime exemption amount is so high, it's over $5 million. The dirty truth is to shelter a lot of wealth these days, you don't need much more than a rev trust or a living trust and a will, maybe a little bit of lifetime gifting or an irrevocable trust if you want to. But that Hodge case was, that stands for the proposition that, look, if we're getting into what the dead person intended, that's not the best issue to be decided on a summary judgment, right? So you see consistently summary judgment rulings and motions to dismiss making their way up to the appellate court well before trial. Okay, so that was Espinoza, right? And we were talking about whether extrinsic evidence can be used or not. But remember now, the estate of the decedent has a malpractice action or malpractice claim, as the estate is always in privity with the attorney, right? So if you're the nieces or nephews in Espinoza, and you lose, right, because the lawyer didn't draft quick enough, and you're claiming that the lawyer wasn't competent enough and didn't prepare the will and have it executed with reasonable dispatch, and you lose under the Espinoza gaze of the prior document. You're not in it, so you lose, and the court doesn't entertain any extrinsic evidence, so you're out. You don't even get to testify. I guess the drafting attorney doesn't get to testify about what the client wanted. They just look at the document, the prior will, and you lose. Remember, the decedent's estate always has a malpractice claim, right? The decedent's estate has a malpractice claim, but how many PRs, how many personal representatives, other than those who are disgruntled beneficiaries who didn't get in the new will, are going to initiate litigation and sue the dead person's attorney? What about tortious interference with an expectancy, right? There was a big law review article written within the last year or two all about tortious interference with an expectancy, and how it derived and whether it's needed or not. And, why do we need another tort? Why are we permitting somebody to sue somebody about a bad inheritance or a botched inheritance? Isn't there enough equitable or probate remedies out there? Can't we have a judge determine what will is valid or not valid, or whether a duty was owed or not owed? But tortious interference with an inheritance or tortious interference with an expectancy does seem to be a growing tort. We see it being filed more and more. We have a very vigorous defense practice. We represent a lot of beneficiaries. We represent a lot of personal representatives or trustees who are being sued for tortious interference with an expectancy. So what if you're a disgruntled beneficiary? You might not be able to sue the lawyer for malpractice. Can you sue him for tortious interference and say, hey, you messed with my inheritance and you did so in a poor way? I don't know that you get over the duty owed hurdle. We'll talk about duties owed a little later on. The Gallo v. Brady case was a CRT case, right? And that also dealt with an issue of extrinsic evidence, right? And the Gallo v. Brady case was a 2006 case, right? So 17 years after Espinoza was issued, the Fourth District Court of Appeal examines Espinoza in the Gallo v. Brady case, right? That was a CRT case, and the issue of extrinsic evidence comes up, right? Following a client's death, the PR brought a legal malpractice claim against the law firm or a lawyer, and alleged that, look, you created this CRT, but it didn't qualify under the rules and the regs and the code, and we ended up paying in excess of $72,000 in estate taxes. It was a botched CRT, and so evidently the estate was trying to recoup the estate taxes that should have been or could have been avoided, and alleged that the purpose of, and so brings a legal malpractice claim against the lawyer for the decedent, alleging that, look, the purpose of the CRT, the charitable trust, was to save on federal estate taxes, and the trust failed to comply with the rules and regs. And as a consequence of that, causation, right, now I've got damage, $72,000 in estate taxes paid that shouldn't have been paid, right? And so the lawyers got a summary judgment issue in their favor, right? They argued that the trust instrument itself did not contain language reflecting that its purpose was federal estate tax savings, right? That the grantor's intent could not legally be established by resort to extrinsic evidence. And the fourth reversed. And the fourth drew a distinction between the Espinoza case and this case, right? And then first of all, the fourth said, look, we believe a jury could look at the facts and without resort to any extrinsic evidence, reasonably infer that one of the decedent's purposes for setting up the damn trust, the charitable trust, was to save federal taxes. That's not a stretch. You don't need extrinsic evidence from that. And that you chalk that up to kind of the reasonable inference rule, right? So many times clients or prospects come to you and they say, well, this happened, but I wasn't there, but I know it. And they feel bad because they're not eyewitnesses, and that's okay, right? Judges are used to drawing inferences from the evidence that you present at trial all the time, and they draw reasonable inferences from the facts that are presented, and they make conclusions, right? They find facts and they make conclusions of law. And then secondly, Gallo v. Brady, that court said, we reject the claim, the lawyer's claim, that Florida law prohibits resort to extrinsic evidence under the circumstances of this case. Why? Well, Espinoza was limited, it said. It only stands for the proposition that a would-be beneficiary may not establish by resort to extrinsic evidence that he or she was intended to benefit from a will. Nothing in the Espinoza opinion suggests that when a legal malpractice claim is brought by the PR on behalf of the estate, the introduction of extrinsic evidence of the testator's intent is prohibited. So, if you're trying or defending legal malpractice cases, not only do you need to know about causation and damages, and in the Gallo v. Brady case, it looks like the damages were easily quantifiable, but you need to know about exclusionary principles of evidence. What can you object to? What can you attempt to keep from coming in? And what comes into evidence? And under what circumstances does extrinsic evidence come in? And when can a court entertain that? Number 3, exception to the privity requirement. A limited exception to the privity requirement in the area of will drafting, allowing intended beneficiary to file a legal malpractice claim for losses resulting, should be from, not from, a lawyer's actions or inactions where it was the apparent intent of the client to benefit that third party. The apparent intent. That's a huge hole to drive that bus through, right? Kind of like judgmental immunity. Wow. That's kind of amorphous. That's kind of big, right? Well, what does this quote mean, right? Because I know we talked about intent, but then Espinoza says in the bad will drafting case, just look to the prior will. Don't look to the intent as the client intended when he hired or she hired the lawyer who agreed to draft the will. Look to the intent as expressed in the prior will. Does that make any sense? should we still be looking at prior wills? Well, as late as 2012, Florida appellate courts are only granting standing to those intended beneficiaries who are in the will, the prior or existing will. Never mind what the decedent asked you to do and what you promised to do and what you were even paid to do. All that matters, really, is what the prior will says, the one which the decedent wants changed. I think that's going to change. I think that's evolving. And so I think you're going to see a lot of tension in law. And I think you're going to see courts getting away from the Espinoza and even the Hodge gaze or analysis of looking only at the prior will. I think they're going to look to the facts and circumstances regarding the retention. I think they're going to allow extrinsic evidence, namely testimony of why the decedent, why the client hired the lawyer and what was supposed to be done. And then you're going to have a trial on whether that conduct was reasonable or not. Did you neglect that client entirely? You're going to be on the hook. Were you reasonable? Did you prepare a draft reasonably and send it to the client? Did you follow up reasonably? And did you offer to execute it? And blah, blah, blah. Then you're off the hook. I think you're fine. A party is an intended beneficiary only if the parties to the contract clearly express or the contract itself expresses an intent to primarily and directly benefit the third party or class of persons to which that party claims to belong. Right? So if you have a legal services contract that says, I'm going to provide estate planning services for you, that's pretty bland and amorphous and pretty pro-lawyer. If your legal services contract says, I'm going to provide services to alter your will and insert your 9 nieces and nephews who didn't inherit under your prior will, then to me, under the Dingle case, that contract for legal services expressly intends that your services benefit those 9 nieces and nephews, right? That class of persons, right? So I guess if you're a lawyer and you're drafting legal services contract, you're going to keep things bland and not be as specific. So, you know, I guess one thought floating out there is, in light of Dingle, can you draft around it? Can you say the services which you have retained the law firm for are personal to you? There are no third-party beneficiaries of this legal services contract. Probably not, right? You know, as lawyers, we're held to high standards, and I don't think we can draft our way around that. I don't think we can certainly draft something that is self-serving when, at least under our fact pattern or hypothetical, we were hired to prepare a will to put the 9 nieces and nephews in. So I don't think we can do that. What was the Dingle case? Well, that was a 5th DCA case from 2014. And this dealt with the deed. This dealt with the gratuitous transfer, right? A lawyer was hired to draft documents for the gift or the conveyance of certain real property, okay? And evidently the client said, we're going to transfer property from an entity, a foreign, a non-U.S. corporation that owns the real property. I'm your client, I'm this man, but I'm also the sole shareholder and I'm an agent of this foreign corporation, this Panamanian corporation. Okay, and I want you to prepare a quitclaim deed. I want you to make a gift or a piece of real property from this entity, this Panamanian corporation that I own. I want you to give it to the Dingles. And the lawyer does that. But evidently, some of the corporate documents were prepared in Spanish. And evidently, the lawyer got an English translation of a power of attorney that was originally drafted in Spanish, and it purportedly evidenced or proved or showed that this gentleman, the client, had the authority to transfer this Panamanian corporation's real estate to the Dingles. So it sounds like the lawyer did some due diligence, did a little bit of homework, checked some things out, prepared, drafted, had the quitclaim deed executed, and then recorded it. And then you know what happened. The client dies. He has a spouse. The surviving spouse, widow, challenged the conveyance. The 5th District ultimately concluded that the power of attorney actually did not authorize the client to make a gift from the Panamanian Corporation to the Dingles. The conveyance was invalid. So what happened? The Dingles sued the lawyer. And the lawyer said, you can't sue me. I'm not your lawyer. I'm the dead guy's lawyer. The estate can sue me. You can't sue me. And the 5th examined all of this, and the Dingles said, hold on. We're third-party beneficiaries. Lawyer, you had a contract with the dead guy. You agreed to provide legal services. You did provide legal services. I assume you were compensated. You followed through on all of that. Clearly, we were third-party beneficiaries. How couldn't we be? Read the deed. The deed says we're bennies. You gave us the property. You prepared the deed that gave us the property. How can we not be intended third-party beneficiaries, even though we weren't a party to the legal services contract that you signed with, or that your client signed with your firm? The client or the relationship between the lawyer and the dead guy, even though we weren't parties to that, we were third-party beneficiaries. So what did the court say? Well, it said, although privity of contract may create a duty of care providing the basis for recovery and negligence, the lack of privity does not necessarily foreclose liability if a duty of care is otherwise established. A person who is not a party to a contract, like the Dingles, may not sue for breach of that contract where the person receives only incidental or consequential benefit. Well, in this case, the Dingles were supposed to get a huge benefit. They're supposed to get this real property. Read the deed, their name's on it. To find the requisite intent, it must be shown that both contracting parties intended to benefit the third party. It's insufficient to show that only one party unilaterally intended to benefit the third party. Well, I think the deed would show that, don't you? What's interesting about the 5th District is they looked at 2 Iowa cases very, very closely. They looked at a case called Holsapple v. McGrath, Holsapple, 521 Northwest 2nd, 711. It's an Iowa Supreme Court case from 1994. And the Schreiner case, Schreiner v. Scoville, Scoville, 410 Northwest 2nd, 679, also from Iowa, but 7 years earlier than the Holsapple case. That was a 1987 case. And in Iowa, much more plaintiff friendly, right? The Iowa court looks to, 1, the desirability of affecting the grantor's intent. 2, the general policy of providing a remedy for a loss. Wow, that's a plaintiff's lawyer's dream, right? And 3, the need for an effective deterrent to future negligence. Wow, now they're talking about deterrent remedies. Wow. So the 5th looks to this language and this analysis by the Iowa Supreme Court in this Dingle case, and they also discuss Espinoza, and the 5th concludes that the Dingle's 3rd amended complaint makes allegations sufficient to bring it within this narrow exception to the privity requirement in legal malpractice cases. The Dingle's complaint contains sufficient ultimate facts which, if proved, show that they were intended beneficiaries of the client's, now the dead client's, contract with the lawyer. Wow. Okay. So, and then the 5th lists a number of cases, including some non-lawyer cases, that hold service providers liable for negligence to persons whom it knows and intends, who it knows or who may rely on those services. So, in the Dingle case, the claim of negligence against a lawyer depends upon a claim for professional negligence. The Dingles have asserted the cause of action for professional negligence. They've alleged sufficient facts sufficient to sustain their vicarious liability claim. So in the Dingle case, at least if you're in the 5th District, you are waving as a flag if you're a plaintiff. Those Iowa cases and those 3 points of law that the 5th discussed from that Iowa case, right? Much more pro-plaintiff, much more challenging in defending legal malpractice in the 5th with that 2014 Dingle case. Now remember, Dingle was not a will drafting case. It was a deed case. It was you didn't draft the deed properly and I didn't get the real estate case. So are Florida District Courts of Appeal more relaxed on the privity exception in a family limited partnership or gift case or a deed case rather than that type of case that says my mom wanted you to put me in the will and you didn't do it and now my mom's dead and I'm not in the will? It appears to be. I think so. That seems to be the trend. So if you're defending bad estate planning or negligent will drafting cases, you take comfort in some of these cases. And if you're outside of that, if you're in a gift case or a deed case, the cases and the analysis appears to be more pro-plaintiff. What's the limitation of these district courts of appeal appellate opinions? Well, when the intent is thwarted because no intent is visible in the prior will, the shortchanged beneficiary must open up an estate, get appointed PR, and seek to file a malpractice action on behalf of the estate, all within 2 years, 9511-4A, right? So we shouldn't forget that 1, there's a 2-year statute of limitation, and 2, the estate can bring a malpractice claim. And who's going to open up the estate? Who's going to be the PR? And is anyone going to oppose you from doing that? Right? You know who's going to oppose you is the person who got the benefit of the gift or the conveyance, or who will get the benefit of a gift or the conveyance if it's found out to be improper. Okay, so we're well into our 2nd hour. Let's talk about the statute of limitations. You know, you've got a 2-year statute of limitations. The question always becomes, when did that cause of action accrue? When should have it accrued? When did it accrue? When should I have known that it began or accrued? And did I exercise due diligence in learning about that? When does a cause of action accrue? Well, generally, it's when the last element constituting the cause of action occurs, right? So you see the Arrowwood case. You can also look at the Pete Marwick case, right? Redressable harm. Remember that concept from earlier? When the damage has occurred, the last element of most causes of action is the damages, right? There was a duty, there was breach, it caused damages. We don't always know right away whether there is damage. Sometimes it takes a little time. So the practice generally is for malpractice attorneys to try to discuss matters with a lawyer and their carrier and maybe to enter into some type of a tolling agreement. So for statute of limitations purposes, a cause of action for legal malpractice does not accrue until the underlying adverse judgment becomes final, including exhaustion of appellate rights. So that's in the litigation context. This is the first point in which there is redressable harm. Again, we see that term redressable harm used. Until then, a malpractice claim is hypothetical and damages are speculative. Right? So you need to quantify the damages, you need to know they're certain, and you need to know that there's no way of altering that or changing that, like through appellate rights or through a review process. And finally, we recognize that, look, mere knowledge of possible malpractice is not dispositive of when a malpractice action accrues. That's the Law Office of David J. Stern PA case from 2007. You can also look at that P. Marwick case. So can I draft around liability, John? Can't I just, I draft really well, I write really well. Can't I just draft a legal services contract that gets me out of this? And you see that from a lot of other service providers, right? If anyone's hired a contractor or an accountant or any service provider that's going to do work on your house or perform services, everyone's trying to limit their liability, right? Environmental companies that are going to perform a phase 1 or phase 2 on real property that you own, or a soils report company that's going to analyze the soils in your vineyard or on your vacant piece of land that you're under contract for. They all want to try to limit their liability. And so you see that quite often that says, the parties agree that the extent of liability would be limited to the greater of $50,000 or the compensation for services rendered, right? Well, that's hooey. That's ridiculous, first of all. When I see that language on behalf of a client, I ask the service providers to eliminate that, right? Well, why in the world should I agree that your liability is limited, but you're not going to limit my damages through your negligence? That makes no sense whatsoever. Oh, and by the way, I assume that you have errors and omissions or malpractice insurance just like I do, right? The one reason you have errors and omission insurance or malpractice insurance is not only for you, for a selfish reason to protect yourself, but it's also for your client, so that there's a pool of money, so that if something does go wrong, there's a pool of money that can satisfy a claim. And you, service provider, I assume you should have that. So why are you trying to limit my liability to the amount of compensation that I pay you? Look, if you make a boo-boo on my taxes and cost me $500,000 and it only cost me $5,000 for you to pay you to prepare their return, I don't want to limit my liability to $5,000 if you made a $500,000 boo-boo, right? That's just silly. Lawyers, unfortunately, can't do that. We cannot, under our ethical rules, agree to limit our liability by contract. We're not Joe Average, we're not civilians, we're lawyers, and we're held to a higher standard. So let's get into Florida legal malpractice cases, issues and potential traps for the unwary. And I guess I would chalk this up to things that we see out there, right? Earlier on, after we discussed the outline for today and kind of the basic stuff, we talked about perspective and highway to heartburn and better practices and issues which we as litigators come across. That's this part of the webinar. That's this part of the live Florida estate planning and malpractice webinar that we're going to focus on now. Stuff that we see that causes us to pause. The Castleberry case in spendthrift trusts, right? Generally speaking, the intent of the grantor matters when they create an irrevocable trust, not a revocable trust, not a living trust, but an irrevocable trust. And you can generally put spendthrift provisions in there that say, hey, trustee, you can distribute income or principal to my beneficiaries, but here's what I don't want you to do. I don't want you to let the beneficiary assign his or her interest in the trust. I don't want you to permit the beneficiary to assign any interest in the income or principal. And I don't want you taking any money and paying off the beneficiary's creditors. And generally that works, right? And the focus has always been on the intent of the grantor. The person that creates the trust, puts the money in there, can within certain realms and certainly within the state's public policy determine how the money is going to be used or not used. One of the exceptions to that, however, based on public policy, is that we can't have an irrevocable trust of which we are a beneficiary of thwart a support or maintenance payment we're obligated to make or pay. So you see the Florida statute 736-0503, exceptions to the spendthrift provision. A spendthrift provision in a trust is unenforceable against the beneficiary's child, spouse, or former spouse who has a judgment or court order against the beneficiary for support or maintenance. So the Castleberry case, spoke about that, Berlinger v. Castleberry, right? And references those statutes that you see, 736-0503 and 736-0504, right? And talks about that statute and that statutory concept. And so the issue kind of comes up is if you're drafting irrevocable trusts, or you're drafting revocable trusts and you're discussing the irrevocable nature of them when the grantor dies, one thing you shouldn't say is, by keeping all this money in trust, don't worry, no one will be able to get your kid's inheritance. That's just not true. If the kid gets divorced, if your adult son or daughter gets divorced and there's a judgment of support or maintenance, that family law lawyer, that divorce lawyer, is going to call me or call you and say, give me a hand, I've got to pierce this trust. I read about this Berlinger v. Castleberry case, and I read about these statutes under this thing called the Florida Trust Code, and I think I can go get that money to satisfy this maintenance or support, right? And that seems to be coherent and consistent with other aspects of Florida law, right? If you're a spouse, you owe a duty of support to your other spouse. Even if there's a prenup that says upon death or divorce, what we each get is limited. You can't use a prenup to neglect your duty of support for your spouse in the state of Florida. So, what you probably should do as a good and conscientious estate planning attorney when you're preparing an irrevocable trust, or you have any discussions with a client about the safeguarding and professional management of trust assets for a beneficiary, such as an adult son or adult daughter, is to tell them in writing, please recognize under Florida law that trust may be pierced and the beneficiary's interest may be used to satisfy a support or maintenance obligation, such as if your adult son or daughter gets divorced. Evidentiary hearings. Are you handling hearings? A lot of probate lawyers administer estates. They open up estates, they file petitions, they do a fantastic job. A lot of estate planning lawyers create wills, draft trusts, amendments, are wonderful resources to families and spouses and senior family members who create wealth. But when somebody passes away or when there's a trust lawsuit from a beneficiary, are you handling evidentiary hearings? Well, if you're not a trial attorney, that's probably not a great idea. And that may come as a self-serving comment because all our firm does is handle disputes, trials, and appeals. But the truth is that evidentiary hearings are evidentiary, and you need to know how to introduce evidence, how to attempt to preclude the introduction of evidence, and you need to know whether there's hearsay within hearsay, and you need to know how to lay a foundation and get testimony in or keep it out. And it's a lot more than just going to court and arguing. I mean, is evidence required? Every hearing except an 845, a UMC or an ex parte hearing is an evidentiary hearing, right? And as one former judge said, I need stuff in front of me. And what he meant by that was you need documents or testimony in front of his honor so that he or she can weigh that, draw reasonable inferences, assess the credibility of that testimony or that evidence, and make findings of fact, and then apply the law and make conclusions of law. So if you're in front of a judge, there is a constant and repeated sin of estate attorneys or probate attorneys in Florida that I will just get up there and argue. And oral argument of counsel is never evidence. You actually need documents, and you need to know how to get them in, and you need to know how to lay a foundation for a witness to make sure they're competent to testify, and you need to know who's going to lay a foundation to get particular documents in, and whether you can do that with a records custodian affidavit in the case of documents you may assemble from a financial institution, or from, for example, a hospital, or regarding medical records. Are you bringing a court reporter to court? Really, really important. We bring a court reporter absolutely to every single hearing, including 845s, ex partes, and UMCs, so that there's a clear record. The only exception to that is after consulting with our client, if it is strategically advantageous for our client not to have a court reporter there. And there are certain circumstances from a litigation strategy standpoint where you may not want a court reporter there. But we bring one to every hearing. Why? Because judges talk about things at hearings, and we may want a clear record of that because I can't take down what he or she is saying fast enough. Or I might, quite frankly, just get it wrong. So there's a record that we can look at to remind me or refresh me about that. And other things come up that aren't always set for hearing, right? And the court might make a command or tell us what to do, and we need a record of that. Did you file a response so that the appellate record is clear of your client's position? This gives trial lawyers heartburn. You should have a clear record, right? When there's an appeal, one of the things that an appellate attorney has to do is prepare the record, right? That goes up to the fourth, or that goes up to the District Court of Appeal. What's down there? You know, deposition transcripts, hearing transcripts. It's more than just the pleadings, the complaint, and the answer, or the petition and the response, right? It might be a whole bunch of other stuff. So other than sending an email to opposing counsel, which is not going to be in the record, did you respond to that motion? Did you set forth your argument in opposition to that motion and cite your legal authority? Is there a clear record so that if things go south and a month, 6 months, a year, 2 years later, an appellate court is reviewing that, did you protect your client's position? I hinted at this earlier. A lot of probate lawyers think they're just going to go into the court, and certainly if the judge just hears me and hears my eloquent argument and I'm such a good advocate, certainly they will rule in my favor. Oral argument is never, ever, ever evidence. Argument of counsel is never, ever evidence. And there's a case, you see the Smith case cited there, that illustrates that point, right? In fact, the court, the fourth, at least in 1982, putting its foot down, rejecting the use of unsworn assertions made by attorneys as evidence. That's a little bit stronger than just saying oral argument of counsel is never evidence. Waiver dropping the ball, non-litigate is litigating. Okay, did you get all your arguments in? Was everything on the record and the transcript prepared by the court reporter? Did you get all your arguments in your response or in your motion? Did you raise everything? What about affirmative defenses? Did you raise those, right? Why are we concerned about that? Well, simply put, if you don't raise stuff, they're generally waived. Well, you might say, I can amend. You may or may not be able to amend. It's true that district courts of appeal in Florida, particularly the fourth DCA, they bend over backwards to say that amendments should be granted liberally, and many cases are reversed and go back to the trial court where the trial judge would not permit an amendment, right? Very, very common. But you got to raise those defenses and raise those positions. And so if you don't, you certainly can't raise it too close to trial. It might be too late, right? It may be prejudicial, maybe not. And you certainly can't raise an issue on appeal that you didn't raise at the trial level. So you're raising all that stuff, and you see the Florida Rule of Civil Procedure 1.140B talks about defenses. Right. So one of the most common mistakes that we see out there is the lack of affirmative defenses, right? You see almost two extremes. You see lawyers who list a zillion affirmative defenses And judges don't like that, just like they don't like 30-page complaints and 10-count complaints. They want a plain statement of the facts, right? And they know that the devil's in the details, and that comes out through evidence at trial. But the other side of that equation, or the other side of that legal coin, is not raising affirmative defenses. I mean, are you answering the petition to revoke probate if you're not a litigator? You shouldn't be, because you not only have to admit or deny the allegations, but you need to raise affirmative defenses, and you may or may not need to file a counterclaim. And then the question becomes, if you're filing a counterclaim, is everybody before the court? Do you have to serve people other than the petitioner with notice of the counterclaim? And how are you going to do that? Are you going to do that by formal notice or otherwise? But one of the most common mistakes that we see regarding affirmative defenses is standing. Failing to raise as a defense, lack of standing. And remember what affirmative defenses are. Affirmative defenses kind of say, yeah, but. Yeah, let's assume all the allegations against my client are true, but I still win, and here's why. But standing, you have to ask yourself consistently, why or how can this petitioner bring this claim, right? And think about it. Not everybody can participate in the probate administration, right? You can't have somebody get off the tri-rail in West Palm Beach, walk a few blocks east and north, and get to the main courthouse and start participating in courtroom 4B in some probate proceedings. You have to be interested in the estate, right? You need legal standing. You need enough connection with that estate or that decedent that the law will permit you to participate, right? You need enough connection. You need to be affected by the outcome of that proceeding such that you have the legal ability to participate. And so many times we see people without standing bringing claims or filing motions or filing an answer or doing something in court. And you have to sit back and say, hold on. You can't do that. You're not entitled to do that. So that's a common issue that we see. However, take a look at the Hansen case. The Hansen case might suggest otherwise. You can read that, the citations there. So generally, as I hinted at earlier, you can't raise an issue on an appeal that wasn't presented to the probate court. And my law partner, Rob Hauser, who's board certified in appellate law by the Florida Bar, constantly reminds us of that. One of the things that Rob always wants to see is what's the record on appeal? What was raised at the trial court? Is there a writing or a document that's filed? Is there something that was in front of the judge that raised this issue such that it is preserved for appeal? And I can argue that on appeal, because I can't raise things on appeal that weren't raised at the trial court. So if you're a non-litigator and you're filing or answering the petition to revoke, that's a concern to me, because I want to make sure you have the right affirmative defenses. Can you amend or seek to amend affirmative defenses? Indeed, you can. What about will contests? If a petition to revoke is filed, are there prior wills that also disinherit the petitioner who's trying to revoke probate and overturn the existing will that's been offered or admitted for probate? And are you raising the doctrine of dependent relative revocation and standing, right? And so the doctrine of dependent relative revocation says, hey, there's a presumption in Florida law that the dead guy or the dead woman didn't want to die without a will. And if for some reason the present will is found to be invalid, or if a part of the present will is found to be invalid, prior valid wills may be revived, right? And they may be given effect. But you have to plead that, and you have to know how to plead it. There's certain procedural and evidentiary hurdles to that. So you can read all about that in the estate of Murphy. That was a more recent case, 184 Southern 3rd, 1221. It's a second DCA case. It goes into the doctrine of dependent relative revocation pretty well. You also see the Carey v. Dubois case there as well. 2nd District, 2009. Carey v. Roke, excuse me, R-O-C-K-E. Fourth issue on this topic: who's your client, right? Who do you owe a duty to, right? The determination of an attorney-client relationship is a question of fact. The test for determining the existence of an attorney-client relationship is a subjective one, and it hinges upon the client's belief that he or she is consulting a lawyer in that capacity and has manifested intention to seek professional legal advice. So what does this mean for the probate attorney, the estate planning lawyer? Well, it means that even if you don't have a legal services contract, you still may have some type of an attorney-client relationship that would prohibit you from doing certain things, such as revealing communications, taking a position or a lawsuit or a case adverse to a prospect, any number of things. So it's going to be a reasonable one. And in your situation where you're representing individuals and family members, and let's face it, we talked about the probate wars at the very beginning. Family members don't get along, right? And there's this $56 trillion that's being passed from the World War II generation to subsequent generations. People are fighting over it, so you need to be careful. You know, that prospect who calls you up and talks to you about stuff, or dad or mom or an estate or a brother or a sister or a stepmom or a stepdad, be very, very careful, because even though they might not hire you, you may be prohibited from participating in an estate or a trust because of that communication with that prospect who never hired you. So what we do at our firm is we have a professional who takes the time to carefully speak with every prospect who speaks to us, and she evaluates whether there's a conflict or a potential conflict, and reviews prior clients and also reviews former prospective clients, right? People who called us who wanted to hire us but didn't hire us. And only then do we make a determination whether we can speak to that person or not. Number 5, who do you owe a duty to, right? And you can see the little caricature from my book, Pankowski's Trustees Guide, where everyone is chatting about stuff in the limo after the funeral or on the way to the funeral. So who's your client, and who do you owe a duty to, right? Well, the Dingle case that we discussed a little earlier was a case regarding whether a duty was owed to a non-client. Remember the Dingles who didn't get that real property, even though there was a deed that says you get this property, you're the grantees. There was a subsequent appellate decision that says the power of attorney that everyone thought was sufficient to grant the client the authority to transfer the property was not sufficient, and that deed was not valid. So you had an intended grantee of real estate, and of course the spouse challenged the deed and said, hold on, not so fast. You don't own that real property. That deed is ineffective. Bring it back to the estate, right? And the Dingles in that case conceded. They said, we agree we don't have an attorney-client relationship with the lawyer. I don't even know if they ever met him or knew him for that sake. But they were third-party beneficiaries. And they were third-party beneficiaries of what? Of the contract between the lawyer and the now deceased client who hired the law firm. Why did the client hire the law firm? To benefit the Dingles, to give them real property. Plaintiffs survive. Motion to dismiss. So in the Dingle case, it also explored not just a legal malpractice case, the elements of which we discussed at the beginning of this live webinar, but also a third-party beneficiary claim. A third-party beneficiary claim, the Dingle court tells us, is a contract with an intent that the contract primarily and directly benefit the third party, breach of the contract, and resulting damages. So what's our takeaway from the Dingle case? Our takeaway from the Dingle case says, don't just sue the lawyer for legal malpractice, bring a cause of action for a third-party beneficiary claim. Cite Dingle, cite those elements. So does Dingle create an end run around the privity requirement? Well, with the third-party beneficiary claim, perhaps it does. But if you plead it properly, in light of Dingle, you probably can survive a motion to dismiss. I mean, to me, clearly, if a lawyer comes to you, if a client comes to you and says, prepare a deed, give the Dingles the property, they're intended beneficiaries, even if their name is never reflected in a legal services contract. In the Dingle case, you can get the deed into evidence, I would think, pretty easily, and you can read it and say, well, that's about as clear as it gets, right? That's like a commercial contract that says, I want you to do this for so-and-so. So how is a deed drafting retention different than I want to put my nephew Johnny in my will retention? How's it different than the Espinosa case, right? How's it different from the type of case that the bad will drafting case where the client just doesn't live long enough, you know? So you can read the Hodge case that we mentioned a little bit earlier. That was where an intended third-party beneficiary sued the decedent. What about guardians, right? If anybody does any guardianship work out there, you've probably read the SATA case, and there's actually two of them. I think the first one was in 2012, which we're not going to discuss. But the SATA v. Connors case, Florida 4th District Court of Appeal, 2015, answers the question, does a guardian's attorney have a duty to the alleged incapacitated person of the ward? And the fourth is saying yes, right? I think the SATA case is a very, very important case. And particularly, I think it's important because of the analysis that the fourth engaged in, right? And the fourth talked a lot about that. And they talked a lot about how the work is really for the benefit of the ward of the alleged incapacitated person. So what's your takeaway? Well, your takeaway, I guess, is twofold. One is that courts now seem to be expanding the intended third-party beneficiary definition of an attorney-client relationship. And you can read the analysis and say that the fourth employed. But it wasn't a will drafting case, right? And so the question becomes, are we stuck with these will drafting cases where you only look at the prior will and say you're either in it or you're out, and if you're out, you're done? The Dingle case, which is a deed case, we talked about the charitable remainder trust case, we talked about the FLP case, and now you see a guardianship case where an intended third-party beneficiary is being expanded, or at least the definition. So you want to think about whether there are third-party beneficiaries out there. And then I guess if you're concerned about that stuff, right, I guess if a lawyer called me and said, I've got a dead client, I get along with, fill in the blank, the spouse or the daughter or the son, but I'm concerned about fill in the blank, the spouse or the daughter or the son suing me for malpractice. Is there anything that we can do? And I guess the analysis that you would conduct is there any notice that you can provide to the person that you're concerned with, such that the 2-year statute of limitations begins to run? Is there anything that you can disclose that would assist you? Does it make sense to disclose information? What does your legal services contract say, right? We have everybody sign, every client signs a legal services contract. And we have this kind of standard contractual language that you hire us, we agree to work for you, and we'll provide services and blah, blah, blah. And it's a relatively short contract, only about a page and a quarter after the letterhead. But we do have a more detailed terms of engagement that we attach that says a whole bunch of stuff, like he can fire us at any time. And if we have a fee dispute, or if you're going to bring any claims against us, we're going to do it here in Florida. And for you estate planning attorneys, that might be important to you, right? And the issue of a mandatory forum selection clause may be important to you, right? Because many times you probably get hired from somebody who's in New Jersey or New York or Boston, and they're going to move down here, and they may have a residency up there, and they want to establish domicile down here, and they want you to prepare new estate planning documents. By the same token, you may have a client who also owns some non-Florida entities like LLCs or partnerships, and you may or may not do some work for them. And so the question becomes, do you want to agree in advance that if you disagree, that Florida is going to be the forum, right? Do you want to be a Florida lawyer defending your fees or your conduct in a Florida court of law or a New Jersey or a Massachusetts court of law? So our rules do permit us to have a mandatory forum selection clause that says if there's any matters, whether for compensation, fees, or claims between client and lawyer, those shall be brought only in a Florida state court, which shall be the exclusive venue and shall have exclusive jurisdiction over all these matters. This is a mandatory forum selection clause, and if you read appellate decisions, you'll see that there's a difference between a mandatory forum selection clause and a permissive forum selection clause, or what I describe as a poorly drafted forum selection clause, right? You want to use the word shall, you want to use the word exclusive, you want to use mandatory, you want to talk about venue and jurisdiction. You don't want to have a forum selection clause that says any disputes that arise between law firm and client may be brought in Florida. That's permissive. That's not a mandatory forum selection clause. And conceivably, then you're getting into an argument, about whether you can be sued up in New Jersey or in other states. Okay, we are approaching the second hour, so we're going to start winding down, but we still have a number of issues to get through. You heard me mention a no representation letter. If a prospect calls, or even if an existing client calls and discusses with us a potential new or different matter, we do one of two things. We send them a contract, or we send them a no representation letter saying, thank you very much. We really appreciate it on behalf of everybody at the firm. We're very flattered that you've thought of us for your current legal needs. Regrettably, we're unable to assist you, or I haven't heard from you, and I'm writing to confirm. Forgive how straightforward this communication is, but we find it to be a best practice. You didn't hire us. We're not your lawyers. You're not a client. We're not rendering any services to you. I'm unaware, or I'm uncertain what applicable statute of limitations or other time constraints you're involved in, because we didn't get into it. You should consult an attorney at once to advise you of your rights. If you don't file suit or exercise your rights within the time prescribed by law, you can be forever barred from seeking damages or otherwise enforcing your rights. A clear, concise communication that's in your file, because clients or prospects, particularly disgruntled prospects, sometimes have convenient amnesia. What about end of work letters? When your role ends, when your work is done, do you send that an end of work letter that says, God, thank you very much. It's been a pleasure assisting you. We're very grateful that you thought of us for your legal needs. Forgive how straightforward this communication is, but we find this to be a best practice. We are not doing any further work in your matter because it has concluded. We have returned all original documents and things to you, or in the alternative, you didn't give us any original documents and things, so I have nothing to return to you. We have no paper file. We do, however, have PDFs of all documents related to your matter, but you've received copies of all of those. Thus, I have nothing to send to you. We have appreciated all of this. We're closing our file. We're not doing any further work. Thank you very much. Kindly think of us in the future should your legal needs arise or change. Right? With something like that, you should avoid the issue of, well, I thought you were working on that. No, I told you to work on that. You said you were working on that. Or there's still more stuff to do. right? We have an ongoing duty of communication, and those seem to be the most helpful. What about getting you paid? Lien on files and charging liens. So I'll take this time to plug a webinar we're going to have sometime in the first quarter of 2017, probably February or March. And we're going to do an hour general credit, maybe ethics credit on charging liens and lien on files. And the reason for that is there's a big misunderstanding of what a charging lien is. There's also a big misunderstanding of how you get a charging lien. And generally, you aren't putting language, permissible language, in your agreement for a valid charging lien. And you can. And they're effective. And there's 9 cases there on that slide in front of you. If you want to know about Florida charging liens, read those 9 cases. You'll learn everything you need to know about charging liens in Florida, but we're afraid to ask, or you can just listen to my webinar. Free of charge. All of our webinars that provide CLE credit for Florida bar members are free. You can email Amanda at phflorida.com, get the link, or you can get the date and time for that when that's finalized, as well as the course number. You know, when we talk about advising the estate planning attorney or the probate attorney on ethics and malpractice, you know, something that gives us heartburn is these lawyers who just blindly say yes, right? The bobblehead acquiescer, right? You cannot be pursuing something in blind faith, not only without bouncing it off of someone, but without questioning it, right? You're the type of attorney where the lawyer calls up and says, do this, you say, okay. You know, you can't do that. You've got to spend a little bit of time analyzing it and determine whether it's in the client's best interest or not. You need to spend a little bit of time analyzing why he or she is doing that. God forbid you communicate with them and talk to them and question them a little bit about it and ask them about that. Blind faith isn't a service strategy. This doesn't happen often, but God, if there's a client who has not told you the truth, you need to sit down and carefully analyze what you do. And in the estate and probate world or the trust world, you know, that seems to arise when people misrepresent about who the heirs are, or whether someone was married or validly divorced, or how many heirs somebody really has, right? Such as a non-marital child that they keep from you, or whether an accounting was produced, right? The accounting context isn't always a lie, right? Civilians, non-lawyers, non-trust lawyers in Florida just don't understand what an accounting is. They think sending you a document with nothing more than a few columns is an accounting, or a letter is an accounting. They don't understand that it has a particular legal significance other than a financial statement. Explaining things to clients like a good and conscientious attorney would, right? That's a buzz phrase that a colleague of mine used when he was deposing a witness, right? We should do that, or at least endeavor to do that, right? We should explain things and confirm things to clients and opposing counsel like a good and conscientious attorney would, right? We get criticized for billing for that. We get criticized for billing a communication like an email or a letter in a point 1 or a point 2, but the truth is just like an appellate record at trial, you should have a written record of what you're discussing, what decisions were made, who said what to whom and why. So let's take that conscientious topic, and now let's talk settlement for a little while, and let's talk settlement agreements. Why are we going to discuss that? Probate lawyers love to settle things, or maybe I should say probate litigation clients love to settle things. We're always getting ordered to mediate, right? All the time. And I'm always asked to mediate, right? All the time. Everybody knows that probate matters. Before you go to trial, you go into mediation. And a lot of people are trying to develop successful mediation practices because some of them think it's easier than billable hours. So settlement agreements are prevalent and there's some recent cases, or there's some important cases and some important concepts that are worth speaking about when we're having a CLE on legal malpractice. Failing to advise the client of risks of not accepting a settlement proposal is an important analysis and an important piece of data. Okay, really, really important. Don't be the type of attorney who gets a proposal from opposing counsel or a settlement agreement from opposing counsel and sends it to your client and says, here you go, let me know if you want to accept it. If you have any questions, let me know. Take the time to analyze it, explain it to the client, and try to analyze it and advise them of the settlement risk. Here's what may or may not happen if you accept this proposal. Here's what may or may not happen if you reject this proposal and go to trial. Here's what may or may not happen if you counter this proposal. Right? In the Sauer case, you can read all about that. You can read about an offer of judgment, Rule 1.447, Statute 768.79, right? And in that case, a lawyer was sued for failing to properly advise the client regarding the risks involved in rejecting a settlement offer. And the client testified in this case in a scathing manner, right? The client said everything lawyers don't want to hear, right? And you have to kind of wonder whether the lawyer really said this. Probably not, right? Because this client in this case said the lawyer said things, well, the client in this case who sued for legal malpractice was basically saying the attorney was saying you can't lose. This is an open and shut case. There's no way I can lose. I'm 99% sure this case is going to be won, and blah, 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 blah. And the Sauer court goes to great lengths to talk about the importance of settlements to clients. And sure, we recognize that society, as settlements are fine, and an attorney has a duty to utilize ordinary skill and knowledge in advising the clients. And then it says, look, you're not off the hook just because your case settled. And I think that's an important point that should be stressed, right? If a client settles a case, that doesn't mean they can't come back and sue you. Sauer says you can, right? We can discern no basis for concluding that an attorney is insulated from liability for failing to exercise ordinary skill and care in resolving settlement issues, right? And they cite the Crosby case further on down the line. And they talk about the judgmental immunity issue, right? About good faith and all that rut. So the Sauer case causes some concern for attorneys. Don't think that just because a client settles something that they may not come back and sue you if your level of service was not competent. The X factor, attorney's fees, right? That's what I call the attorney's fees, the X factor, right? In fee shifting statutes. In the probate world, right, with trusts and estates, the losing party can pay costs. Losing party can pay attorney's fees under certain circumstances. And even without the Florida Trust Code or the Probate Code, there are other fee shifting statutes and concepts that can be used, such as 57105. We talked about the proposal for settlement or offer of judgment, the rule in the statute. There's also fees in the form of sanctions or surcharge that can occur. What does your legal services contract say? What are your ongoing communications to your client say about attorney's fees, right? We put language in our legal services contract that say, look, we want to be upfront with you. If you lose, you're going to pay costs. And in the probate, trust, guardianship, or family law world, you may also get tagged with fees. Yes, you may have to pay the victorious side or the other side their attorney's fees in addition to paying ours. And in the trust or estate context, no, that doesn't mean you can necessarily use trust or estate funds. Maybe coming out of your personal hide, maybe coming out of your pocket or from your inheritance. So you can reread that Air Turbine Tech case that we mentioned it early on. That was an attorney's fee case that caused a little bit of angst just reading it. Are you complying with orders and commands? An order from a judge is not a suggestion, it's a command. It's as if the judge is standing over you telling you what to do. I'm shocked at lawyers who ignore or think they can amend the judge's order just because they agree with opposing counsel. And you should explain the consequences of not complying with the order or command to your client, right? If you don't comply with an order, that's contempt. Bad things legally happen to those who are in contempt of court. That's not good. You never want a client to say, well, I wouldn't have done that except my lawyer didn't tell me that, I could have my motion denied or my complaint dismissed or blah, blah, blah. So explain it to them. Guardianship matters. Who is your client? We discussed the SATA case earlier, SATA v. Connors. 15, don't give your files, estate plans, drafts, or other documents to non-clients. This might seem pretty damn simple and obvious, but a lot of estate attorneys are giving clients and files to non-clients. Like if you represented mom or dad and they die, and son calls up and says, give me the file, and you guys give it to them, and it's not appropriate. There is a Florida bar rule on confidentiality of information. There's no carve-out for spouse. There's no carve-out for adult kids, even if they say please and speak nicely to you. Attorney-client privilege. We know that there's unique issues and an exception to the attorney-client privilege for communications and documents where parties claim through the same deceased client. Will signing and execution ceremony. Do you keep a log or do you keep a memo that reveals what occurred at the execution ceremony? What was said, to who retained the original, who signed in what order, when somebody arrived, who was present, and who left. It can be much more powerful than a videotape of the will signing, which I find generally to be poorly managed and ineffective and even harmful. 18, more settlements and settlement agreements. You think you have a deal. Be careful of Monday morning quarterbacking and clients who have a rear view that's 2020. The Pierce case, a 2013 case, would tell you not so fast. And then you can read the Richardson v. Knight case. You think you're settling matters orally on the record with a court reporter in a courtroom, think again. If you're not using a written agreement, stuff can come up. Whenever you're doing something on the record orally and the clients are there and they should be there, the judge should always ask the client and swear them in if they understand everything, if they understand the consequences of this agreement, and if they have any questions. Cases have been reversed because that hasn't happened. What about later found assets? Where you settle something out on a Monday and somebody takes X to settle all claims and to be satisfied in full from an estate or a trust, and lo and behold, a month later, they find out that there's other assets that nobody knew about. That's the Sugar case. What about rejected settlement offers and proposals for settlement? That air turbine case had some big dollars. That involved an offer of judgment for $500,000. The offer was rejected, and what happened? There was a loss at trial. There was a summary judgment loss. There was a motion for fees. The fees motion was in the millions and millions of dollars. The costs motion was approaching $1 million. That was a judgmental immunity case that we discussed earlier. But this was an example of the client is rejecting an offer to settle this for $500,000 because the client obviously thought there were substantially more damages to get at trial, and that didn't happen. 19, advising clients about standing fees and costs pre-mediation. Anytime prior to attending a mediation, it's kind of a best practice to tell the client what they owe you, right? Because they're probably going to use that in any type of calculation in determining whether they're going to settle, and if so, how much, right? What is the client's net after all expenses, including attorney's fees? Creditor claims, are you asking your beneficiary client if the decedent owed them anything, right? That's a heartburn, right? A beneficiary calls you, retains you regarding an estate or a trust, and they're a beneficiary, and there's issues regarding beneficiary rights. And you never stop and say, hey, did the dead guy or dead woman owe you any money or owe you anything, or is there a contract where you had rights that you need to enforce such that you're a creditor and you have to file a claim? Are you confirming it in writing? Did the surviving spouse sign a prenup? Is there a marital settlement agreement out there? Is there a contract or an order from a divorce or a marital agreement that creates rights or creates obligations in the decedent? If so, the other person to that marital settlement agreement or that spouse to that prenup or postnup as a creditor, you have to enforce those rights. Right? We see that all the time when the worlds collide between family law and probate law. Right? There's an outstanding marital settlement agreement, or there's a judgment of divorce and equitable distribution of property requiring the now deceased former spouse to hold a life insurance policy or pay for a life insurance policy or transfer an asset or pay certain money, and that's not done. Now you're a creditor of the estate. You've got to file a statement of claim. So there's a lot of very recent legal malpractice cases outside of the state of Florida. I list some of them right there that are related to estate and trusts and probate. You can read those if you want. Let's try to wind up with ethics and we'll conclude. Your ethical rules, the McCormick v. Cox case, that involved a law firm, a trustee, and a trustee who's a lawyer hiring your own law firm, as well as the disclosure and non-disclosure of big fat fees. Every lawyer who serves as trustee should read that. Every lawyer who advises a trustee should read that. Check out the McCormick v. Cox case. There's our main courthouse in downtown West Palm Beach. Number 2, how do ethical rules impact our practice? There's the Florida rule for communications to our client. The Sauer case, that's the case from 2000, the 4th District in Florida that I mentioned before, where someone was supposedly not advised of not accepting a settlement offer or the risk of not accepting the settlement offer. You need to consider strategies, decisions made, issues to be discussed, but don't overpromise. And then Sauer talks about the settlement. So this kind of repeats what I said earlier. Don't dump a settlement agreement into someone's hands and say, here you go, let me know what you think. It's your job to let the client know what you think. Your legal services contract, are you limiting what you're doing for the client? Are you limiting the scope of your representation? You should spell out the scope of your representation or what you're doing. You're hiring me to respond to the petition to revoke and to bring a counterclaim. You're hiring me to sue your trustee for an accounting, and if we find bad stuff, I'll amend it and sue for breach of fiduciary duty. You might even say what you're not going to do, or you might even say, you asked me to do this, but I politely decline. You should seek an attorney for that issue immediately. Charging liens, liens on file. There's 2 different types of liens in Florida that an attorney's entitled to under certain circumstances. One is a lien on files, right? If you have an outstanding balance, although you have to return any original things that a client gave you. And then there's the charging lien, which I mentioned earlier, and maybe you'll attend our webinar on that and hear me speak about that. Our course number was 1608 416N as in Nancy. The course name is Advising the Estate Planning Attorney. You're entitled to 2.5 credits for ethics in general. Everybody who listened, I want to thank you for all your time. This concludes our seminar on Advising the Estate Planning Attorney. I invite you to attend another webinar by P.L.L.C. Hauser. And if anybody was not able to attend the entire webinar, you can email amanda@phflorida.com, and an audio and slideshow should be available through Dropbox or some other means within 48 hours. My name is John P.L.L.C. from P.L.L.C. Hauser. Thank you very much for listening.